All right, everyone, welcome. My name is Vlad Perju. I'm the director of the Clough Center for the Study of Constitutional Democracy and a faculty member here in the law school. It is a pleasure to welcome you to this afternoon's very special event, and a particular welcome to Professor Jim Whitman. This is the first event of the year in the Clough Center's Distinguished Lecture in Jurisprudence series. When Paolo Barroso, who is here and directs this series of the Clough Center, and I first thought about these lectures, we wanted them to be a forum for work reflecting on the importance of jurisprudence, its depth, its versatility, its scope. And so it is perhaps no surprise that over time, the series has brought here not only jurists, but also historians and political philosophers, urban designers and theologians, providing them with a forum to reflect from within their own traditions of thought on questions that interest us: the nature of power, law's relation to culture in a political community where people are said to be governing themselves, questions about law's construction of time and of itself, the understanding of political space. We thought, Paolo and I, that only an inquiry of this scope could be useful, could perhaps reveal some of law's secrets about what keeps societies together. Now, very few fields of practical and speculative inquiry can make a stronger claim of insight on these matters than the field that is a home of today's distinguished lecturer, comparative law. I thought of how to capture in this brief welcome what the House of Comparative Law looks like, and I found the following, something that was written not specifically about comparative law or about law in general. It comes from Bertolt Brecht, an address to the Danish Workers' Union. Where else? An actors' union on the art of observation. To observe, Brecht tells actors, you must learn to compare. To be able to compare, you must have observed already. From observation comes knowledge, but knowledge is needed to observe. A conundrum, you see, and many a comparativist, at times perhaps the field itself, got terminally entangled in this conundrum. Professor Whitman has not. He has not only navigated these waters, for that would indicate skill, but also more than just an element of chance. Nor has he used some special radar to avoid it. No one can avoid that. His method has been to understand what it means to know, to learn, to observe. The work has not succumbed to the tensions inherent in the enterprise. It is work that turns to history when theory of law is insufficient, and to theory when law's history seems all but unchartable. To those who would use comparative law as a tool to make a point about the richness of each culture in its infinite complexity, Professor Whitman has recalled that cultures change, that law has a practical dimension, that sometimes some of its functions transcend any one society. To those who would use comparative law to make the opposite point about law's universalism and universality, he has shown how the close study of legal norms, both within and across legal systems, will reveal layers of rich meaning in specific combinations of cultural and historical forces, combinations that shape how the mind applies itself to facts. Perhaps most importantly, Professor Whitman's work teaches that using comparative law to make a point, any point, might seem appealing, but ultimately is neither helpful nor particularly successful. This is how Whitman built the House of Comparative Law. Inside that house, you will find work on the theological roots of the criminal trial, about the relation between dignity and liberty, about shame sanctions and harassment law, about racial segregation, about the laws of war, about the understanding of privacy across legal systems and legal culture. Professor Whitman comes to us as the Ford Foundation Professor of Comparative and Foreign Law at Yale. His topic today is the two primitive modes of imagining property, owning land and owning human beings. Please join me in welcoming Jim among friends at Boston College.
Thanks so much. That was a gorgeous description of comparative law. I'm not sure I can live up to it. Let alone following Bertolt Brecht is a pretty tough challenge too. But I'll do my best. Thank you very much. Thank you all for coming. It's really an honor and a pleasure to be here. What I think is a very cultivated institution, Boston College at least, I thought that I could speak to what I imagine is a cultivated audience about the topic I'll speak about today. I've handed out some quotes. I will be reading excerpts of these quotes as I go along in the paper. If you'd like to see the full quotes or just check on whether I'm being accurate in my descriptions, you're welcome to do that. I thought at least it might enhance the experience if I had you. I've made them available. So I'm going to begin with the first of the quotes here, a very famous quote from Blackstone. There is nothing which so generally strikes the imagination and engages the affections of mankind, wrote Blackstone, as the right of property. But when the right of property strikes our imagination, what is it that we imagine? What sorts of things engage our affections? For Blackstone himself, there was one prime answer: land. He famously celebrated the right of property as that sole and despotic dominion over the external things of the world in total exclusion of the right of any other individual in the universe, and then went on to explain that by the external things in the world he had in mind in particular the dominion of land, of a determinate spot of ground or a particular field. Only as a sort of afterthought did he add, or a jewel. When the right of property struck the imagination of William Blackstone, what sprang to his mind first was the thought of an Englishman as the sole and despotic proprietor of real estate. In this, he was, of course, faithful to the traditions of the common law, an inheritance of a medieval feudal legal order in which holding estates and land was always the key to social status and wealth. In the Middle Ages, as medievalists say, land equaled power, and that was still true in Blackstone's day. In England, 2.5 centuries later, land is still what strikes the property imagination in common law America. The word property in American English, as the Merriam-Webster definition explains, signifies something owned or possessed, specifically a piece of real estate. Needless to say, there are many other kinds of things that can be owned or possessed in the American common law, just as there were in Blackstone's time. But when Americans hear the word property, a plot of land is still the image that springs to their minds first. Meanwhile, American law includes many distinctive legal doctrines that suggest how deeply real estate engages the affections in the American legal culture. Among these are the home mortgage deduction, little known elsewhere in the world; the American conception of the right of privacy, strongly and distinctively defined as privacy within the walls of the home; the widespread political rage over takings, and not least, the castle exception in criminal law, which gives Americans, alone among the inhabitants of economically advanced countries, the quasi-feudal, if not despotic, privilege of using deadly force anytime they believe they have been attacked within their own domain. Much the same orientation toward real estate marks American legal scholarship as well. American law school hypotheticals still begin in more or less medieval fashion with the fictitious piece of real estate called Blackacre. And the American scholarly literature includes a notably high proportion of books and articles on the theory of property in land. Reading American scholarship, one sometimes has the impression that the theory of property is the theory of land. Even when American scholars analyze other kinds of property, they show a striking tendency to draw on analogies to realty. The influential writings of Henry Smith and Tom Merrill, for example, imagine property of all kinds as something with boundaries that must be clearly marked, as something from which trespassers may or may not be excluded. And when Americans talk about the philosophy of property, their inescapable first point of reference remains Locke, whose theory offers, of course, a justification for the ownership of land. This more or less taken for granted assumption that owning property involves, in the first instance, the dominion of land, and perhaps even the right to kill anyone who trespasses on it, comes so naturally to Americans that they may be surprised to learn that it is not universal. Isn't land the first image that springs to mind everywhere when people hear the word property? Yet the right of property has been conceived differently in other legal cultures, both in the present and in the past. The present-day civil law world offers many examples. In Germany, for one, the dictionary definition of property dismisses the idea of property as land as antiquated. There, as elsewhere on the continent, it goes without saying that what Blackstone called the Gothic castle of feudal law has long since been demolished. German property law is post-feudal law, and so real estate plays a significantly lesser role in German thinking, while the German rate of home ownership is notoriously low. Germans have another reason for rejecting the idealization of land as well. They remember the ideology of Blut und Boden, blood and soil, that put the link between racial Germans and their land at the center of Nazi politics. Post-war Germans know how easily the affection for land can degenerate into something frightening and dangerous. But perhaps the most provocative example of how the property imagination can vary, and the one that I want to focus on today, comes from the legal cultures of the past, for it is a striking fact that in various past times and places, the paradigmatic image of property was frequently not a plot of land, but a human being. Classical Roman law is a prime example. When the ancient jurists discussed basic problems in property law, they did not speak of a fictitious piece of real estate called Blackacre, but of a fictitious slave called stichus. In the surviving texts of classical Roman law, stichus is eternally being bought, pledged, and bequeathed. And when Roman students learned the most basic original formula for claiming ownership, what they learned was not, I declare that this land belongs to me, but I declare that this man belongs to me. Needless to say, the Romans owned many kinds of things, including land, and Roman law had plenty to say about all of them. Nevertheless, as I will suggest today, it is a fair guess that where a plot of land is the image that first struck the imagination and engaged the affections of an Englishman in the age of Blackstone, what first struck the imagination and engaged the affections of an ancient Roman was the image of a slave. If there had been a Roman Merriam-Webster, its definition might have read property, something owned or possessed, specifically a human being. Nor is ancient Roman law the only such example. The law of early modern West Africa is another case. I'm coming to my second quote here, and a particularly fascinating and much discussed one. Early modern West Africa was the principal source region for black slaves during the high age of Atlantic slavery. It was a region whose law, like the law of ancient Rome, conceived of property in the first instance as property in humans, not property in land. Here is how African historian John Thornton describes the contrast between West Africa and Western Europe. Slaves were the only form of private revenue-producing property recognized in African law. By contrast, in European legal systems, land was the primary form of private revenue-producing property. Historians and anthropologists believe that this dramatic clash between an Africa where what you owned was human beings and a Europe where what you owned was land had large implications for the course of the history of black slavery. When early modern Portuguese, Dutch, French, or English traders sailed to West Africa to purchase slaves, they purchased them from a world in which, as in ancient Rome, it was normal and acceptable that persons should be property, and then transported them in nightmarish conditions to a world in which being human property was an exceptional and profoundly degraded state. These examples suggest the truth that is my point of departure in this lecture. As we survey human history, we can identify a noteworthy and at times momentous divide in the way property rights have struck the imagination. On the one hand, we have traditions like those of ancient Rome and early modern West Africa, whose affections seem to have been engaged largely and perhaps primarily by the prospect of owning human beings. On the other, traditions like those of early modern Europe, contemporary America, and perhaps Nazi Germany as well, whose affections seem to have been engaged instead by the prospect of owning land. Owning humans and owning land. I am going to call these the two primitive modes of imagining property. They are primitive in two senses of the word. They are primitive in the descriptive sense, that they are the root conceptions of ownership from which other conceptions have been generalized, as I'll try to show. They are also primitive in the normative sense, that they are both conceptions of ownership that stand in some tension with the ideals of civilization and rule of law. Owning human beings is a practice whose evils we can all see, but it is not clear that owning land has always been all that much better. I also have a historical thesis to propound. Our Western law of property is the product of a historic evolution from one primitive mode to another, from an ancient world in which property was imagined in the first instance as property in human beings, to a medieval and early modern world in which property was imagined in the first instance as property in land. This shift has not been rightly understood by scholars, but it has had large consequences, and we must grapple with it if we are to take the full measure of the conception of property that we have inherited from Blackstone, and it still continues to capture the American imagination. My purpose in tracing the history of these two primitive modes is in part to demonstrate the depth of the cultural differences in conceptions of property. The right of property is indeed forged in the Blackstonian imagination, and the imagination and in turn is shaped by cultural and historical forces. There is no natural relationship between persons and the external things of the world, such that ownership is always conceived in the same way in all human societies and all periods. That does not mean that the property imagination mechanically determines how the right of property plays out in practice. The contrast between the two primitive modes that I will present is a contrast in the way human beings have desired and justified the right of property, not a divide over what they have in fact owned. It is not the case that Romans owned only slaves and never owned real property, nor is it the case that there were no slaves in Blackstone's England. The difference is not a difference in property economics, it is a difference in the forms in which property has been primarily imagined and desired, and the language by which the right of ownership has been primarily justified. It is a difference in the psychology of ownership, and in what I will call the climate of justification. Romans liked to imagine themselves as slave masters, and believed in the legitimacy of slavery, and they generalized from the ownership of slaves and conceptualizing the ownership of other external things of the world. 18th century Englishmen, by contrast, like to imagine themselves as sole and despotic owners of real estate. Contemporary German law looks askance at both views. My topic is vast, and I cannot cover all of it in one lecture. I'm going to spend the bulk of my time today on problems in the interpretation of Roman law, and here's where I told myself, Boston College is a place with learned, cultivated people who wouldn't mind a lecture with a lot of Roman law in it. I hope that's true, because I can't rewrite it at this stage, you know. But I'll try to make it interesting, I promise. I hope to convince you that the problems really are uncommonly interesting and uncommonly important. The Roman orientation toward owning human beings was analyzed in powerful writings by some great names, by Marx, by Weber, and by a Nazi theorist little known in America today, Max Kaiser. Scholars today have lost sight of this truth about Roman law, however, and I aim to revive it. In the latter part of the lecture, I will sketch the great shift toward the ownership of land that began in the Middle Ages and culminated in the Age of Blackstone. What I can offer is no more than a sketch, though. But throughout, I will put the accent on the ugliness of the human psychology of property rights in past centuries. And I will close by asking whether that ugliness is still with us. The idea that there are two primitive modes of imagining property, owning humans and owning land, and that Western history has been shaped by a shift from the first to the second is not new. Far from it. Versions of the same idea can be found in the writings of two of the greatest figures in the history of scholarship, Karl Marx and Max Weber. Both men argued that Western history had been the theater of a grand transition from slavery to landholding, from the ownership of humans in antiquity to the ownership of land in the Middle Ages. Citing Marx and Weber is a ticklish business these days, however, since the theories of both men are uniformly rejected by modern scholars. In fact, modern scholars reject Marx and Weber so confidently and even vehemently that it may seem obviously wrong to suppose that any such transition ever took place. For that reason, I would like to begin by reviewing the theories of Marx and Weber, explaining why scholars discard them, and showing why their writings are nevertheless still full of wisdom. The theories of Marx and Weber are probably familiar to you. It's a cultivated universe, as I say. At least in vague outline, Marx and his followers founded their economic history on the proposition that there was a transition from the slave mode of production of antiquity, in which the means of production, a human being, was owned by a master, to the feudal mode of production in the Middle Ages, in which the means of production, a piece of real estate, was owned by a lord. Weber steered clear of Marxian economic theories, but his account of the sweep of Western social history rested on the same fundamental contrast between a slave-owning antiquity and a land-owning Middle Ages. Where Weber primarily differed was in putting the accent on military conquest. In Weber's version, the economy of the Roman Empire in its prime rested on the mass exploitation of slaves acquired through war. Ancient Rome was a military order much more than it was a commercial one. As Roman military expansion slowed to a halt, though, and especially with the fall of the Western Empire, Europe shifted to the exploitation of serfs tied to the land. Classic arguments. Now, decades of scholarly work have completely discredited both of these classic theories. I don't know how much detail I should go into in explaining how they've been discredited, but I'll say a little. There is no persuasive account by which ancient Greece and Rome could be described in Marxist terms as slave economies. Actually, they kind of look capitalist, the way people talk about them these days. Marxist economic history, like the rest of Marxist economics, is nonsense. Weber was wrong to think that the Romans fed their unquestionably large appetite for slaves through war. The slave population had other sources. Actually, child exposure may have been the main source of slaves in antiquity. Also kidnapping, commercial slave raiding, and even self-sale. The ancient economic and social histories of Marx and Weber are fictions, and today it is the mark of any well-trained scholar to dismiss them. This is how you show your standing as an ancient historian or medievalist. You begin by saying Marx and Weber were obviously wrong. There were, as for their accounts of the post-Roman world, those are fictions too. There was no such thing as a serfdom that took hold with the fall of the Roman Empire and endured unchanged for 1,000 years thereafter. Feudalism is a term that medieval historians don't even like to use any longer. I won't go into all of the details. It's just all wrong. Whatever Marx and Weber were talking about, they were not talking about economic and social realities. But that does not mean they had nothing to say. Both men were trained lawyers. More than that, both were brilliant readers of the legal sources. Indeed, as their critics have often complained, the shortcomings of their theories had to do precisely with the fact that they relied too heavily on the legal sources, which are ultimately of limited use for understanding the history of economy and society. Yet, if Marx and Weber were mistaken as economic and social historians, they were nevertheless uncommonly sensitive intellectual historians of the law, and their arguments went to the heart of the mental worlds of the legal texts they studied. Ancient Rome was not a slave economy in the Marxist sense, but Roman law really did put slavery somewhere near the center of its imaginative universe. Feudalism and serfdom hardly existed in the way the older literature supposed, but the so-called feudal law that ripened slowly in Europe from the Central Middle Ages and took full shape in the 16th century really did put real property at the center of its imaginative universe. There is a history to be written of the great shift from the law of owning humans to the law of owning land, for which we can still proudly cite Marx and Weber. It's just not the history Marx and Weber wanted it to be. It is a history of the Western property law imagination. And the right question to ask about it is how much and in what way a large-scale historical shift in the property law imagination mattered. The most direct way to approach that history is by tracing the semantics of two critical terms in the Western legal tradition inherited from Rome, dominium and servus. Dominium is the principal term for property in the Western tradition. It is the term that appears, for example, in Blackstone's familiar formula, despotic dominion, that's just the English version of dominium, about which I will have more to say toward the end of the lecture. At its earliest Roman origins, dominium was a term used paradigmatically for the ownership of slaves and beasts. In subsequent centuries, it underwent a semantic transformation. In the Middle Ages and the early modern period, dominium came to be closely associated with feudal lordship. In the parlance of the Middle Ages and the early modern period, dominium signified the ownership of land, but also the right to rule over the dependence on that land. To have dominium over a piece of property was to be not only its proprietor, but also its lord, maintaining a manorial court and enjoying a variety of lordly privileges. In that sense, medieval and early modern dominium stood somewhere midway between ancient slavery and modern land ownership, encompassing both control of land and control of human beings, both ownership and domination. The restricted sense of dominium as purely the ownership of the external things of the world, without any accompanying right to rule over persons, only began to establish itself clearly in the second half of the 18th century, and even then only slowly. As I will suggest even in the writings of Blackstone, the idea hung on that to be the owner of land was to be in some way a lord. The modern idea of property as involving a purely material interest is a late arrival in Western history. The semantic history of dominium gives us one critical glimpse into the history I'm talking about. The history of servus, which meant slave in antiquity and sometimes serf in the Middle Ages, is another, but I'm going to focus on dominium. Now, for my purposes here, I'm going to focus on dominium. Here I begin with an ingenious study of early Roman property law produced by a superb scholar at a troubled moment in his lifetime and a troubled moment in 20th century history. This was Max Kaiser, professor of Roman law, member of the Nazi Party, an author of a classic study on Roman conceptions of property that appeared in 1943 at a moment when the Nazi Empire was just beginning to recede from its zenith in the aftermath of Stalingrad. Seeing the history of property law from a Nazi point of view can tell us some useful things, not only about the history of property law, but also about the ugly side of the psychology of ownership. Kaiser's book set out to solve a crucial mystery about the history of the term dominium in early Roman law. In early Roman law, there was no general concept of property. The early sources simply describe various categories of things of the world, with each category having a distinct name and subject to a distinct regime. Yet sometime around the turn of the millennium, as the Roman Republic collapsed and gave way to the empire, a general concept of property took hold under the name of dominium. This was the moment of the birth of property in Western law, contemporaneous with the birth of the Roman Empire. Why then? Why under the rubric dominium? In a remarkable half-dozen pages in his 1943 book, Causer laid weight on the fact that the term dominium comes from dominus, master, and that dominus in ancient Latin meant specifically master of animals or slaves. This was the key, he argued. The Romans began to speak of their property as their dominium at the moment that they had made themselves domini, masters over all the peoples of the Western world. As the empire triumphed, the Romans started liking to think of themselves as masters over their inanimate possessions, just as they were masters over their slaves, their beasts, and the many nations they had conquered. And I translate a little bit of the Causer here on the second page. Causer describing the Romans being fond of thinking of themselves as slave masters and masters over beasts. It is impossible to read these pages without noticing that Causer, like Blackstone before him, linked the form of ownership to the shape of human desires, and most especially of the desire to dominate. Just as Blackstone spoke of the way that despotic dominion engages the affections, Causer spoke of Romans as liking to think of themselves as slave masters. As Adam Smith put the psychological point, humans own humans not for economic reasons, but because they love to domineer. It is also impossible to read Causer's pages without remembering that they were written at a time when the Nazis were themselves claiming the status of master race over the peoples under their dominion. If Causer saw something in the Roman sources, it must be partly because he saw it in the light of his own experience of history and the attitudes of the Germans among whom he lived and worked. But the fact that he saw Roman property law through the lens of his experience in Nazi Germany does not mean that what he saw was false. It is close indeed to what Marx and Weber saw, and it is borne out by the work of other scholars and by a wider reading in the legal sources. Miles Levin's engrossing 2013 book, Slaves to Rome, for example, traces how routinely the Romans described themselves as masters over the slaves of the rest of the world. Other scholars speak similarly of the legal sources. The historian of ancient slavery, Kyle Harper, to take a prominent current example, is, like all well-trained scholars, at pains to reject the economic and social theories of Marx and Weber. Nevertheless, he too is a sensitive reader of ancient legal texts, and he observes that the way the Roman jurists imagined slavery was consonant with the claims of Weber, fallacious though those claims were. And here I've given you the quote: "The Roman jurists defined slavery as an institution of the law of nations by which one person is subjected against nature to the dominium of another." You can see the rest there. He describes all of this, how much this guided Romans in their thought. For Harper, too, the point is that the Romans liked to think of themselves as members of a conquering slave master class, and to imagine the slaves in their own households or on their own plantations as their war captives, even though few of them had in fact landed in slavery by that route. I suggest that it is against the background of the observations of these scholars, going back to Marx, that we should read our basic Roman sources on the law of property. It should not surprise us that when the jurists worked through basic problems in the law of ownership, their stereotype example was so often the Greek slave stichus. It should not surprise us that when basic teaching texts introduced students to the early roots of Roman law, they spoke of the formula, "I declare this man to be mine." These were teachings that came naturally to a law whose imagination was shaped by the love of domineering. The same can be said of another important part of Roman property law, the basic discussion in the Digest of Justinian of how property is acquired. The first means of acquiring property in these ancient texts, and I've given you some texts, comes under the heading of res nullius, of things that belong to no one. The doctrine of res nullius would have a critically important career in the early modern period, when Europeans would invoke it to justify taking land in the New World. These were lands that belonged to no one, so they could be taken. But in the hands of the ancient jurists, it had little to do with taking land. Their examples were different. They talked about taking dominium, primarily over wild animals, and also over captives in war. As Causer observed, the primitive sense of dominus was master of humans and beasts. When early modern jurists seized on the doctrine of res nullius, they were taking a teaching from a beast and slave conquering understanding of property law, turning a teaching from the beast and slave conquering understanding of property law to the uses of a land conquering. That is not to say that Roman lawyers were unconcerned with land, by no means. I'm expecting the objection. Rome was an agrarian order and law of the land was ample and ingenious. It is only to say that the basic Roman teaching texts and the key figures of Roman reasoning display a notable orientation toward capture and domination as the root of ownership. The ancient Roman world did not have a slave economy in Marx's sense or a war economy in Weber's, but it was a society in which the conquest and keeping of human beings sat somewhere at the core of the property imagination. To sound the full depths of the ancient orientation toward the ownership of human beings, we must look, however, beyond the narrowly legal sources. It is a commonplace that the Roman jurists wrote under the influence of ancient philosophy. I won't read the whole paragraph, I'll just say that if we look at ancient philosophy, it is strikingly difficult to find any developed justifications for the ownership of land, of the Lockean kind, or the kind we use all the time in our property teaching now. What you have instead is Aristotle's theory of the natural slave and various other philosophical justifications for slavery. These all belong to a society in which the conquest and keeping of human beings sat at the core of the property imagination. That observation is sure to sound shocking to modern American ears. Right? What is more horrifying than the ownership of human beings? I'm now turning to the normative question here. How can we do anything but condemn a society ruled by men who were fond of imagining themselves as triumphant slave masters? Nevertheless, before turning to the transformations of the post-antique world, I will say, I think it is important, by the way, to say these nasty things about Rome because well, they are admittedly nasty, because the excessive tendency to idealize the Roman legal tradition among people who do what I do is really deeply objectionable. I was interrupting myself there. Nevertheless, before turning to the transformations of the post-antique world, I want to highlight what seem to me the authentic moral complexities in assessing the Roman slave order. As horrifying as the ownership of human beings is, there is a case to be made that an exploitative order whose legal imagination presupposes the ownership of humans is not clearly morally worse than an exploitative order that presupposes the ownership of land and might even be regarded as morally preferable. How could anybody entertain such a thought? The case is probed in an acute and challenging way in Thornton's discussion of pre-modern West Africa. Thornton emphasizes 2 points. The first is a commonplace among historians and social scientists going back to Marx, but it always deserves repetition. The contrast between the ownership of persons and the ownership of land is not the contrast between one order that exploits human beings and another that does not. The economic reality of the two orders may be nearly indistinguishable, and both may depend on the ruthless exploitation of labor. Both involve domineering. The choice is not between slavery and freedom, but between slavery and alternative forms of exploitation. Thus, Thornton makes the case that West African law was not necessarily more condemnable than the contemporary law of early modern Europeans with their orientation toward land. I'm quoting, just as ownership of land as a factor of production establishes a right to the product of that factor, so too ownership or control of labor, people or slaves, can provide the same right. African law simply established claims on product through slavery rather than through the fiction of land ownership. Follow that argument, I'll give it more, go into it more as we go along. The contrast between slave owning and land holding is not the contrast between darkness and light, but at best the contrast between darkness and deep shadow. Second, and critically, Thornton emphasizes that in the West African world, as in ancient Rome, slaves were not the only persons who were in some sense owned. It was in the nature of a legal order oriented toward the ownership of human beings that many people, even most people, were regarded as being owned in some sense, even if they were not reduced to full-dress slavery. Thus, in West African systems, the status of slaves was closely comparable to the status of junior members of a lineage and to that of wives. In the anthropological literature, this is referred to as the slavery kinship continuum. Similar things can be said about classical Roman law, in which wives were in some sense owned or ruled by their menfolk and children by their fathers. Roman masters, like pre-modern West African masters, acquired property through their ownership of the labor of their beasts and their slaves and the ownership of the labor of their sons. In that sense, the ownership of human beings structured the understanding of almost every aspect of society. Essentially all of society was ranged on the slavery kinship continuum, or perhaps the beast-slave kin continuum. If we bear those background facts in mind, we can get a sense of why it might be the case that slaves might, paradoxically, be better off in such a system than in a system oriented toward the ownership of land. In West Africa, as Thornton argues, there was nothing exceptional about the condition of being human property. The reality of a slavery kinship continuum that reality had a critical leveling effect. It made the condition of slavery less degrading. To use the familiar terms of Orlando Patterson, it made slavery something less of a social death. The West African world was one in which almost everybody was owned in some way, whereas the Western European world rested on a sharper distinction between the lords of land and the rest. Similar things can be said about ancient Rome. Being human property was a very general, though not universal, condition, and it was a condition into which anybody might in principle fall. Much of Roman law and of ancient literature assumes that any free person could suffer the misfortune of being enslaved. This reflected the reality that there were numerous possible roads from freedom to slavery. Free Romans captured in war would become slaves. Exposed infants born free were made slaves. Sometimes free children were sold by their parents. Raiders could descend without warning and capture and sell anybody. It was even not infrequent that circumstances forced free persons to sell themselves. The fascination and horror of these possibilities shaped the literary imagination. For example, in novels such as Daphnis and Chloe or Chaereas and Callirhoe, in which free persons found themselves enslaved, only to be happily freed in the end, of course. The same fascination and horror shaped Roman law, which declared that slavery was an institution contrary to nature and made elaborate provision for procedures by which free persons, falsely enslaved, could claim their freedom. Perhaps in some way it also shaped the extensive Roman law of manumission. These features of Roman slave law belong to a legal order founded on the supposition that any human being might potentially become a piece of property. A kind of notional empathy for slaves was built in, even as Roman masters treated many of their slaves with utter brutality. Thornton is not the only scholar to argue that such an order, brutal though it was, could serve as the foundation for a comparatively, though of course only comparatively, humane slave society. Something closely similar was argued by Frank Tannenbaum in his seminal 1946 book on New World slavery, Slave and Citizen. Tannenbaum contrasted the parts of the early modern New World that received Roman slave law with its declarations that slavery was contrary to nature and its presumption of frequent manumission with the race-based slave law that emerged in North America. The Roman-influenced world of South and Central America and the Caribbean, he argued, proved immune to the worst excesses of North American slave regimes, and in the end developed societies marked by a less virulent racism. Tannenbaum's thesis has long been controversial, but it has been defended by scholars like Bob Catrol and Alejandro Fuente. If Tannenbaum was right, it is because an ancient legal order that put the ownership of human beings at the center of its normative imagination held within it the seeds of a less vicious early modern and modern order. The shift to a normative order centered on land, of the kind that we find in Blackstone's commentaries on modern American law, certainly began in the early Middle Ages and continued throughout later medieval centuries. Nevertheless, I won't go into all the details. It's, again, too much technical medieval history is asking too much of my audience here. Let's just trust me, Marx and Weber were wrong, but there was still something going on. What is nevertheless true, especially from the Central Middle Ages onwards, is that dominium acquired its post-antique focus. I'm sticking again with the history of the term dominium. That term could refer to the ownership of many kinds of things, but it acquired a particular association with the ownership of land and the exercise of lordship over the persons occupying it. As the standard medieval lexica tell us, dominus and dominium, which in antiquity had been in the core instance terms for slave owner and human and animal property, became terms for feudal lord and feudal landholding. And medieval jurists spoke of jurisdictional dominium. That is, dominium as the authority to maintain a seigneurial court with rule over a locality. In that sense, legal language, if not socioeconomic reality, faithfully mirrored the transformation in modes of exploitation described by Marx and Weber. In the imagination of the law, where there had been ancient masters, dominant by virtue of the ownership of human beings, there came to be medieval lords, dominant by virtue of the ownership of land. This was, I note, the same transition that would take place in the United States after the Civil War, as Southern slave owners became Southern landowners with subservient sharecroppers. The full shift to the ownership of land rather than human beings was really only consummated in the 16th century. I'm not going to go into all of that, but I'll give you a taste of what was going on. In the early modern period, the law of private property in Western Europe came clearly to center on the ownership of land, as it still does in the US today. And it's then that the most momentous developments in the transition from owning humans to owning land took place. By the early modern period, Western Europe had become the region that African historians describe, the region where what was owned was not humans, but land. There is much too much to say about this early modern transformation here, but I want to offer a few observations. First, the early modern shift in property law was part of a much larger reorientation toward land in European law. Many domains of the law showed the same tendency to move from a focus on the control of humans to a focus on the control of land. History of kingship is a great example. In the early Middle Ages, there was a king of the Franks. By the early modern period, there was a king of France, king of people to being king of lands. In tandem with this territorialization of kingship came a changing conception of what counted as a realm. Medieval maps did not generally show boundary lines, relying on much vaguer geographic indications, such as, here be Saracens or something like that. Only in the early modern period did map makers begin routinely to ink in sharp borders on their maps and block out different countries in different colors. As scholars of international relations are aware, this was the period of the emergence of clear territorial sovereignty. It's in the same early modern period that the conception of the jus soli, of citizenship by right of birth in a particular territory, emerged. In the same early modern period, in the midst of this wide-ranging and really mysterious turn from ruling over humans to ruling over land, the law of private property, too, was decisively transformed. Just as where once there had been a king of the Franks, there came to be a king of France. Where there had once been owners of slaves, there came to be owners of land. This was a shift with some large historic consequences, few of which I have time to discuss here, but one in particular, which is well known to historians of slavery, deserves some attention. It is a striking expression of the shift to the law of land that from the 16th century onward, free soil doctrines emerged in northwestern Europe. It came to be the law that, while human beings might lawfully be owned anywhere else, most particularly in the New World, it was fine there were no slaves in the territory of France or the Netherlands or England. The most famous early modern decision along these lines comes from Bordeaux in 1571, and I've given you a little quote from it in the sheet, where the court promulgated a rule that modern Americans erroneously associate with Mansfield's famous 1772 decision in Somerset's case, which I imagine you may have encountered. Alan Taylor in his new book says it triggered the American Revolution. According to this 1571 decision, any slave who set foot in France was by very virtue of the contact with French soil made free. There were similar decisions in the Netherlands, and in England itself, such free soil doctrines had already been enunciated in the 15th century. As a result of that, by the way, in the early modern period, there were warehouses technically outside the territory of France in Bordeaux where you would leave your slaves while you went and did your business in France, because if you brought them onto French territory, they'd be free. It's important to emphasize the obvious about these early free soil doctrines. They were not founded in an abolitionist commitment to universal human rights. Right? It is hardly the case that late 16th century France, for example, showed a dedication to the dignity of all human beings. None of these decisions held that slavery itself was universally impermissible, only that it was repugnant to the law of the territory in which the courts in question sat. These were decisions that freed land, not people. Free soil doctrine of this kind, which would reappear in the Northwest Ordinance and the Missouri Compromise, was in that sense a product not of abolitionism as such, but of a larger reorientation toward territory that was taking place throughout the law. Now, my time is short. Let me now return at last to Blackstone, the psychologist of common law ownership. Blackstone, we should recognize, wrote at a critical moment in the formation of the Western conception of property, the moment when the ownership of land was finally, if still gradually, being divorced from lordship. This was a development of Blackstone's own time. Throughout most of the early modern period, in most places, it still went without saying that feudal dominium of land went hand in hand with lordship, just as had been the case throughout the Middle Ages. The link between dominium as ownership and dominium as lordship would not be decisively severed in France, for example, until the Revolution. Nevertheless, from the late 17th century onward, we can follow the dawning of a different conception of land ownership divorced from lordship, notably in England and Scotland. We see it as early as the writings of Locke. Indeed, when we read our Locke, we must be attentive to the silence in his account of the origins of property and land. He doesn't say anything about lordship. In mid-18th century Scotland, we see the theory of a form of land ownership divorced from lordship systematically developed in the reformist thought of figures like David Hume and his disciple Adam Smith. The creation of a concept of land ownership without lordship was one of the great victories of the Enlightenment. There is a hint, though, in the writings of Blackstone of how insecure that victory was. Blackstone certainly did not endorse medieval lordship. Land still equaled power in his England, and perhaps in his commentaries, but not in the old feudal style. Power was exercised in far less formal ways by the landed aristocracy and country gentry. Nevertheless, the older understanding of dominium still echoed in his volume when he came to the psychology of ownership in the most famous phrase in his treatment of property law, despotic dominion. It should be obvious that despotic dominion is a phrase that belongs to the language of rulership, not ownership. Blackstone was not the first to use it. Google Books allows us to identify many uses of despotic dominion throughout the literature of the 18th century, but always in reference to the power and ambition of kings. Blackstone was a man of the Enlightenment, and I believe he was committed to an enlightened concept of ownership divorced from lordship, yet the fact remains that as he tried to capture the psychic roots of ownership, the way that property engages the imagination, he could not avoid speaking the language of domineering. The root of ownership in his mind still lay somewhere in the desire to rule, and the satisfaction of ownership was the satisfaction of being king in one's own domain. It is the insecurity of the victory of the Enlightenment embodied in the phrase despotic dominion that I'd like to close by underlining. The legal history that I have recounted is a history of the primitive psychology of ownership, of what animal ethologists call dominance and territoriality. So two things we see in birds and other primates. They have pecking orders and they have territories. It is entirely right to see that history through the dark prism of the Marxist tradition or through the eyes of the Nazi Max Kaiser. It is a history that begins with slave masters and continues with feudal lords, and its message again and again is the message that humans, like Blackstone when he spoke of despotic dominion, have found it difficult to imagine themselves owners without also imagining themselves lords. Making a healthy property law means combating some deep-seated and primitive human inclinations. It is very difficult to imagine ourselves as owners without also imagining ourselves as rulers. Today, the memory of this long, ugly history of property rights is much more vivid in continental countries like Germany or France than in America. Sometimes this has bizarre and comical results. French property law, for example, rests on the strange assumption that landowners and landlords are inevitably oppressors whose potential depredations the law must combat. The landlord is always the bad guy in France, always the bad guy. American lawyers can see through the nonsense in that, which is certainly all to the better. Nevertheless, I would like to close by offering a plea for the wisdom in the continental view. Human beings are still the animals they were in past centuries, and it is not clear that we can hope for an easy success in suppressing their love of domineering. Contemporary American property scholars, with the admirable exception of Dan Sharfstein, tend to offer remarkably anodyne pictures of ownership. It just makes you rich, or it fulfills you personally, or something like that, Some of you teach property, I'm sure. I fear that this makes them insensitive to what are still lurking dangers. The psychic link between ownership and domineering is not so easily severed. The American castle exception is an obvious example, as is the slogan Blut und Boden. The use of war to conquer territory is another. The world may yet suffer badly over territorial struggles in places like the South China Sea or the Himalayas. In countries all over the world, moreover, we see the ongoing strength of the conviction that wealth and power ought naturally to go hand in hand, whether because the wealthy have a natural right to rule or because those who rule have a natural right to enrich themselves. This is a modern instantiation of the association between ownership and lordship that Enlightenment figures like Adam Smith fought against. Smith's remedy may well remain the best. We must think of the right of ownership purely as the right to pursue material interest, but I think we're foolish and historically illiterate if we imagine that that can come easily.